ownership and possession are these two different concepts in jurisprudence. And as we are aware that ownership is the absolute right, I may say, and legitimate claim over an object, whereas the possession is physical control over that particular object. And now we will be talking mainly on the concept of ownership. In practice, most of the times we have such queries from the client, as we call it in Marathi, sir, जागा माझ्या नावावर करा. मला माझ्या बायकोचं नाव प्रॉपर्टीत घालायचे. I want to add my name, my wife's name in my property. I want to have the property in my name. So where should I apply? So the people what think that if their name is included in light bill, MSAB bill, property tax bill, or for that matter 712 extract or property card, then that's it. They become the owner. But actually, the concept of ownership is quite different, and we'll be seeing these concepts. And at the same time, what are the modes of getting an ownership in the property? Now, you all are aware that right in the property, ownership in the property, one can get either intervoyance, that is agreement between two living parties, or after death by way of will or by of succession. So intervoyance means where in two living persons, a person may get ownership right in the property either by way of sale deed, by gift deed, or release deed. After the death of a person may get ownership either by will or by succession. And succession, the will rather, I would say that the will prevails over succession. So I will just briefly give you the important aspects of gift deed, release deed, and will and the succession. See, firstly, let's start with sale deed. As I suppose that here there are law students in this seminar. So, concept of sale deed, as we are all aware, that the Transfer of Property Act is a very important enactment. We all law students must by heart it, because in practice you will be dealing with this statute directly or indirectly. So, a sale deed is absolute transfer of ownership for the price paid, or partly promised, partly promised to be paid. The payment of price is an essential condition precedent for sale deed. The parties must be of proper age, and in their same capacity they must conclude the contract. And prior to sale, there is a concept called as agreement to sale. Right? We call it as sathekhat in Marathi. So agreement to sale by itself does not create any right in the property. It is just one step below the sale deed. So once a sale deed is registered and a price, what agreed price or agreed consideration is fully paid, then only ownership right in the property get transferred in favor of purchase. So this is also done in the lifetime of the purchaser and the seller. The second important document by which one may get ownership right is a gift deed. Now, Transfer of Property Act Section 122 onwards, you will find the provisions related to gift deed. Gift deed is a very important document which is registered in daily practice. And most important condition of the gift deed is that it is registered without there being any consideration. And the donor is the person who donates the property, who gives the property, and donee is the person who accepts the gift. And unless the person, that is the donee, accepts the gift is not come. So unless and until, so in the gift deed on last page, we always have the column I accept, and then the donee signs for it. So the gift deed is also very important document. And in Maharashtra, if the gift deed is between the blood relations, for example, say mother to son, mother to daughter, or vice versa, or husband to wife, or vice versa, then the stamp duty has been reduced to 500 rupees. But in Pune, they charge in current days 2% as metro surcharge. Subsequent document now I'm now turning to is a release date, or some may call it as a relinquishment date. The basic ingredient of any release date is that a person must have subsisting right in the property. So, for example, I will just give an example. Suppose a father dies and his property then is devolved upon his class 1 legal heirs as per Hindu Succession Act. That is his wife, his mother, and his children, or the children of predeceased son or daughter. So suppose we have a family where the man has his wife and one son, one daughter. And suppose now son and daughter wants to release their right in favor of their mother, then they can certainly do it, because three of them have subsisting right. The moment father died, his property right divided upon three of them. But given a case where suppose a person wants to transfer, a husband wants to transfer his right in the property in his lifetime to his wife, then he cannot execute a release deed because the wife does not have any right in the property because it was purchased in the name of her husband. So relinquishment deed, important condition is that a person must have subsisting right in the property, and then it can be registered. And if it is related to ancestral property, then it only attracts stamp duty of rupees 500 as on today in Maharashtra. Another important mode of getting ownership in the right is will, or which is called as testamentary document. So will is, I would say that is the only document the people don't want to even hear about, because it is related to someone's death. Because a will starts speaking when a person's making it stop speak. So in Marathi we have all said that मृत्यूची वेळ निश्चित असते, मृत्यू निश्चित असतो पण त्याची वेळ अनिश्चित असते. So we all of us know that some or the other day we are all going to die, but we don't know the date and timing of the. So will is the very important document which we advise in day to day our practice to our client to execute the will. See, for executing will, what you can give by will, your self-acquired property or your undivided right interest in the ancestors. So will can be executed. Will has to be written. Will can be executed by a person more than 18 years of age and when he is in sound mind. And what you can have, that only you can give by the will. The will does not require registration by law. The law has exempted compulsory registration of the will. However, practically we advise people that please get registered the will because it does not attract any stamp duty. And when a will is registered, the future problems of getting the probate or letters of administration, as the case may be, get very easily solved. The will is complete only when two attesting witnesses who are not the beneficiary under the will sign in presence of the testator and testator sign in presence of both the witnesses. Another important condition for the will is of medical certificate. So the law nowhere prescribes that a medical certificate of a competent doctor is mandatory. But by practice, we make it a point that the testator gets the medical certificate, because subsequently, if the will is challenged, then the main ground to challenge the will is suspicious circumstances, that the person making will was under not in physical or mental capacity to execute the will. So we do advise to have the medical certificate even if it is not legally mandated. Another aspect of the will is that the appointment of an executor. So to give the implementation of the will, right has been given to the testator to appoint an executor. So executor can be one or more than one person, but it is not mandatory to appoint an executor. So if an executor is appointed, then in the metropolitan cities like Mumbai, Chennai, and Calcutta, the probate is required to be obtained. So probate is mandatory only in these three metropolitan cities. In the rest of the part of the India, probate is not mandatory. Pausing here for a moment, there is a difference between what is mandatory, so what is something which is required to be done by law, and which is I would say directory by law. At some time it may happen that there is no executor and some question pertains related to will is arising, for example related to flat in a society or bank account, etc. And if the authorities are adamant and they ask you to get the probate or the letters of administration, as the case may be, then in that particular circumstances the probate is required to be obtained or letters of administration. If the executor is appointed, then he gets the probate. If executor is not appointed, then the letters of administration is to be obtained from the competent court. And currently in Pune, in Maharashtra, maximum 75,000 rupees is the stamp duty one is required to be paid. It is required to be paid when we obtain probate or letters of administration. So this is the law related to will. And most important factor of the will is that the last prevailing will, what is the last will always prevails. As the law gives permission to the testator to change his will n number of times, depending upon the circumstances, and whatever the last will may be, that shall prevail over the earlier will. Whether last will is registered or unregistered doesn't matter. It shall prevail over the earlier registered will also. So this is the law in nutshell related to the will. And lastly, a person get ownership right in the property by succession. So see, now firstly section 6 talks about the rights of daughters and sons co-partnery property. Now, as per 2005 amendment, which you all must be aware that now daughters have been given the equal right, and recent 2019 three judges bench judgment of Honorable Apex Court. Now they have gone to such an extent that irrespective of date of birth of daughter or irrespective of date of death of the father, the moment daughter is born, she gets right in the ancestral property equally with that of a son. However, if a man dies and without making any will, then Section 8 comes into play of Hindu Succession Act, and his class 1 heirs get equal right in his property. And class 1 heirs, I just few minutes back told that if a male person dies intestate, then his mother, his widow, his son, daughter, and if the son or daughter is predeceased, then son, daughter, son or daughter. So they get equal rights. And if none of them is present, then the class 2 heir comes into, and father, sister, all they have been kept in the class 2 heir. This is related to if a male person dies. Suppose a woman dies, then if a woman dies, then whatever her property is, it is firstly distributed equally amongst her husband and her children or children of her predecessor. So this is related to the property of any woman. And one important distinction here is that any property obtained or taken by any woman becomes her absolute property. So this is not in case of a male, because Section 6 comes in, 6 and 6 might come into play as the case may be. But the property acquired by woman may be from her maternal side or paternal side, from husband, from gift, by will, whatever may be the mode, it becomes her absolute property and she has every right to dispose of in her life. So these are the modes of getting ownership right in India. So intervoyos, so in between by agreement between the parties to living persons, or after death either by succession or by will. So you get the property, the ownership rights in these three particular modes. The getting of ownership does not necessarily mean you also get the possession rights, because as I said, possession and ownership are two different things, and we call as possession 9 out of 10 in law. You must have learned in while learning the jurisprudence. So possession is of utmost importance. So because if you'll find that many court cases are fought in the court just to get the possession or to protect the possession. So if possession is lost, everything is lost. So a person may be having a possession, but he may not be the owner and vice versa. So I will stop here. I have tried to explain as brief as I can related to the concept of ownership.
Sir, what are the powers of a nominee?
Nominee, it is just a stopgap arrangement. Nominee is a trustee. He never becomes an owner in the property. And the law is settled right from 1980 of Supreme Court judgment Sharbati Devi's case, and it has been upheld by subsequent benches as well as benches of Honorable Bombay High. So suppose I appoint someone as a nominee. So this question mainly comes during case of society matter, housing society, because the member has to nominate someone. And now 2016 judgment of Indrani Wahi, in the case of Indrani Wahi of Honorable Apex Court, the court has clarified this point in very simple words, and it has made the job of cooperative societies very easy. That just to transfer the membership in the name of nominee, and that's it. The rights or disputes between ownership, this is the headache of the legal heirs, and they must get it settled either among themselves or through a competent. So nominee has no legal right. It is just a stopgap arrangement as we say.
Okay. And sir, what is the difference between a joint owner and a co-owner?
It's one and the same.
One and the same, there is no difference?
No. See, many a times people ask us that my name is first in the agreement and my wife's is second in the agreement and my mother's is third, like that. So in law, whoever name first or second doesn't make any difference. The number of names, all the persons get equal rights in the property unless it has been specifically mentioned in the sale deed or agreement that this person is having only this much percentage of right and this much is having. Otherwise, all the persons get equal rights irrespective of the number in the nomenclature.
Okay, sir.
Sir, I have one doubt. Say, like, for example, I have a jurisdiction that I stay at Bombay and my property is also at Bombay and as well as at Hyderabad. Then the property at Hyderabad is the name of my mother and the property is in the name of father as well, both together. Two separate properties are there, one in the name of mother and one in the name of father. Both the persons are died. Now, as per the legal position, they have not made a will. Then we have to go for a letter of administration or could be a legal heirship, whatever they demanded. But can we do a probate from Bombay or we have to go all the way to Hyderabad?
See, probate, as you have said, they have not made any will. So then question of probate doesn't arise at all, because
Exactly,
probate,
sir. Yes.
for a probate, it is a condition precedent to have a will.
Yes. What, sir?
So unless there is a will, there cannot be any probate.
No, they have not made any will. Nothing has been made. Then what the
No,
procedure?
then in that case, you have to file an application in either in Hyderabad court or in Bombay court, and the court will just declare you that you are the heir of both the deceased.
But even though
It doesn't confirm any ownership right. Heirship certificate or succession certificate doesn't bestow any ownership right. It just the court recognizes you as an heir.
okay, but even though we can do it all the procedure in Bombay as well, even though the
Yes.
property has been located at Hyderabad.
Because there are two properties, you said. No?
Yes, one property is at Bombay, two properties are Hyderabad.
Then both the courts have jurisdiction.
Okay, okay, sir. Thank you.
सर आपने जैसे बोला कि इफ मदर और फादर इज ट्रांसफरिंग द प्रॉपर्टी बाय वे ऑफ गिफ्ट टू हिज डॉटर और सन, then there is only 2% stamp duty. So is it applicable on commercial premises also?
No, it is applicable only residential premises. That too in Maharashtra.
So it will be not applicable on commercial premises.
So it will be, I think, 4% or like that. I'm open to correction. It will be certainly more. They have made it the 500 rupees provision, or I would say discount. They have made only related to housing and agricultural, residential and agriculture.
Okay, sir, I have a different question. Like you have handled the redevelopment project. So after the societies went into redevelopment project and then the gift is made. So what will be the position after that?
Flat is
So
in
she is
existence.
asking if the society has gone into redevelopment, and while the process of redevelopment is being carried on, the property is gifted. So what will be the title of the?
But how can a property be gift when it is not in existence? The flat is demolished.
Not yet demolished.
Then it can be done.
Okay.
It can be done.
The moment gift deed is executed,
Okay.
at the same time the donee becomes the owner.
Okay.
So whatever new flat is going to be constructed, donee will be entitled to.
Okay, sir. Thank you.
So there is a property belong to two brothers, and after his death of one brother, there is no legal heir of clan. So the property is belong to class 2 heir or different one who have the share in a property.
If there is no class 1 heir, then definitely property.
Yeah, there is no
will be
class 1 alive, and only class 2 heirs are alive. But the property is of two brothers jointly. So the property goes to the second brother who have the share in, or the class 2 heirs can also have to claim the property.
Property you said in the name of two brothers. So they become entitled to 50% undivided share each. So their respective undivided shares will devolve. Their respective undivided share will devolve upon their heirs, class 1 and class 2, whoever may they be.
The brother no have any one class heir, class 1 heir.
अगर class 1 नहीं है तो class 2 में
He's only one in class heir and he's died. And after his death, the class 2 heirs are claiming for the property, and if the brother is also a class 1 heir. So he have the 50% property in share in a property. So he also claim for the remaining 50%, or class 2 heirs have the right of the property.
Firstly, the brother never comes in class 1 heir. Brother or sister comes in class 2 heir. And if after vesting of the property, class 1 heir is dead, as you said, then again that property will devolve upon the legal heirs of that class 1 heir. So it will go on like, shifting. It will be a big family tree you have to do.
Okay, that means the class 2 heir also have the right in a property.
If there are no class 1 heirs, then only class 2 heirs come in. Remember this.
And one thing, sir, if in class 2 heirs there are 3 or 4 people, so both have the equal right, or only one have the right?
All are high equal.
Okay, sir. Thank you.
So there's one question that by relinquishing one's right, does one also relinquishes his or her pious obligation?
Pious obligation cannot be released.
Okay, so if a person relinquishes his or her right, but is still obliged to pay the debts, right, of the...
Pious obligation and rights in the property are two different concepts.
So I have put up a question on chat box, but now ignore as I got the chance to talk to you. See, I have a property in South Mumbai. It's a redevelopment property, and building is, but the flat is in the name of my mother and me. First name mother, second name my name. Now mother expired, father is
Okay.
also not there. I don't have any other brother and sister also. I am the only one. So I'm asking my society to transfer the share certificate in my name. But now they are demanding of the legal succession certificate and something like that. I say it will be going to be too costly. So because I don't have any other brother, sister, there is not going to be any claim. No mother, no father is also. So mother property was actually belonging to my mother, maternal father, mother's father.
Okay.
So now what are the options available which are little cheaper than the succession certificate?
Firstly, the court fee is maximum 75,000 rupees, not more than that. Or irrespective of the rates in Mumbai, you will require to pay only 75,000 rupees. However, what are the legal charges or lawyer's fees that differ from place to place?
Okay.
So otherwise, you have to have heirship certificate from the competent court. You may ask society whether
Hello.
society accepts an indemnity bond from you on 500 rupees stamp paper.
Good.
That if someone makes any claim related to property, then I will indemnify the society. If society agrees to it, then nothing like that. Otherwise, you'll have to have the heirship certificate, and it will take some time, minimum 4 or 5 months.
4 or 5 months for succession certificate. What?
Heirship.
Yeah.
See, succession
Heirship, okay.
certificate is obtained for a movable property, and heirship certificate is to be obtained for immovable property.
Okay.
Sir, any tips for owners for a hassle-free transfer to their successors upon their death?
Most important is to have proper documentation. Many people don't have proper documentation. They don't have agreements ready. They even don't know whether agreement is registered or not. So have a proper master file ready with you. Then I always advise now, see, after COVID days, there is no age bar for death. We must have seen all of us that someone directly, indirectly from our family succumbed to COVID. So life is very uncertain. So I always advise that what is the best day to make a will, then it is today. So before making a will, you have to just write down all your properties and take a help of any legal expert and get it registered at done. So preparation of a will, I always advise these days is a must for hassle-free transfer after your death, because the testator won't be there to see what are the problems faced by his beneficiary.
Okay. And so there's one more question. What are the rights of a child born out of a wedlock? An illegitimate child, sir. What are the rights? If the father dies intestate, so what will be that
Same.
child's rights?
If a father dies intestate, then illegitimate child gets equal share. He is considered as his son.
Okay. And in case of ancestral property?
Then he doesn't get. I think this question is, I'm open for correction. This point is before full bench or larger bench before honorable appeal.
Okay. So this point that ancestral property, it's still a question of law.
Yeah.
Okay. So, sir, thank you so much for such a wonderful webinar. It was a very
Thank
informative
you very
talk.
much.
Thank you so much, sir.
Thank you.
And thank
Thank you. It was my pleasure again. And I'm waiting for another session. If you call me.
absolutely, sir. We'll get in touch with you.